Thank you very much, Laskin Corla. The following motion has been placed on the the following motion has been placed on the Dáil order paper for referral to committee. I move that Dáil Éireann approves the terms of 1. The agreement between the Member States of the European Union concerning the status of military and civilian staff. 2. To the institutions of the European Union, of the headquarters and forces may be able to made available to the European Union in context of the preparation and execution of the tasks referred to in Article 17(2) of the Treaty of the European Union, including exercises, and of the military and civilian staff of the Member States put at the disposal of the European Union to act in this context, done at Brussels on the 17th November 2003, a copy of which was laid before Dáil Éireann on the 2nd of January 2019, and 2. The North Atlantic Treaty Organisation Partnership for Peace Status of Forces Agreement, done at Brussels on the 19th of June 1995, a copy of which was laid before the Oireachtas on the 2nd of January 2019. Subject to the respective reservations, copies of which were laid before Dáil Éireann on the 2nd of January 2019. The Status of Forces Agreement, or SOFA, which is often referred to, regulates the legal and administrative arrangements applied to members of foreign forces operating within the state where they are deployed. It relates to the immunities and privileges extended to members of the Defence Forces when serving on overseas missions as part of UN-mandated forces. It also relates to the case of EU Partnership for Peace, SOFA, to the immunities and privileges extended to members of the Defence Forces when engaged in exercises in EU or NATO and Partnership for Peace member states or on standby for the EU battle groups. All international organisations, including the UN and the EU and NATO, have concluded SOFAs with the states where they have deployed forces or engaged in training missions. In respect of UN operations, the UN concludes a specific SOFA with receiving states, for example with Lebanon in relation to UNIFIL. In the case of EU or NATO-led operations authorised by the UN, either a specific SOFA covering all deployed personnel is concluded, or else the relevant EU or Partnership for Peace SOFA applies to personnel from participating states. In circumstances where members of the Defence Forces are deployed within the territory of another EU member state on training or exercises, or where the relevant overseas mission utilises the EU or PFP SOFA, members of the Defence Force do not benefit from standard immunities and privileges as of right. This is due to the fact that Ireland have not ratified these SOFAs. In such circumstances, separate arrangements have to be put in place through an exchange of letters. However, this is not always possible. Ratification of the SOFAs is designed to address that deficiency. SOFAs are designed to protect military personnel deployed in terms of accidents, third-party liability claims, potential prosecutions and other actions which may be covered by legislation in the host country. The ratification of SOFAs simply means that the Defence Forces can acquire the rights and privileges of these arrangements as a matter of right, rather than having to rely on difficult contentious exchange of letters between jurisdictions which may or may not be concluded on their behalf. The EU SOFA, which is ratified by all Member States except Ireland, it can only come into effect on ratification by Ireland. All other non-aligned or neutral Member States, including Finland, Sweden and Austria, have ratified the EU SOFA. Approval from this House is not required in relation to ratification of the EU SOFA, as this is covered by the Lisbon Treaty. However, I have included in today's motion for the sake of transparency. Ratification of these SOFAs will only extend to members of the Permanent Defence Forces deploying overseas where these SOFAs apply. They cannot apply within the state. As there is a constitutional prohibiting Article 15(2) on Ireland agreeing to receive the base foreign troops on its territory, there is no situation in which SOFA could have application in respect of foreign forces in Ireland, including forces in transit or visiting personnel. In that regard, reservations have been drafted for both agreements clearly articulating Ireland's constitutional position, leaving no scope for ambiguity. The reservation state, Ireland, shall not be a receiving state for the purpose of the present agreement. I cannot stress enough that Ireland's policy of military neutrality is not diminished, circumvented or reduced by our ratification of the SOFAs. If anything, our national position is more strongly discernible following this process, given the reservations we are attaching to our instrument for ratification. Thank you very much, László Foley.